first thing I want to talk about, and I know it kind of seems like a very like basic thing, but I think it's an important distinction to make. It's just like all these terms that kick around, right, for corporations. We have officers, directors, shareholders. There's all these different people that are involved. Shares is the pieces of the corporation, right? We share the corporation, the ownership. I don't think that's actually like why it's called that, but that's how I always look at it, because you're like sharing the ownership. When you own a share, the way I like to refer it to people is, unless there's an agreement that says differently, a shareholders agreement or a contract, you own your shares in the same way you own your shoes, right? They're property. You own it. So if somebody says, we have a company 50-50, we each own 50 shares, that means you physically have those 50 shares of the company. The shares can be written down on a share certificate, but even if they're not written down, you can still have the ownership of the company. If there's only one of you, right, running the company, you own all the shares. The number of shares is the first question I always get, like how many shares do I issue and at what price, right? I'm starting my company, how many shares do I need? So all things being equal, you can do it 100 shares at $1 each or at $0.01 each. That's if there's no other factors on the table. Sometimes there's financial factors, there's accounting factors, right, you can speak to. There could be reason. I won't go into too many hypotheticals, but one example is if you know that the corporation has some value on day one. So my corporation owns a building. Building is worth $1 million. If I buy in those shares at $1 and then I later sell the corporation for $2 million because of this huge asset, I have to pay $2 million of capital gains, right? Because I pay the whole difference between what I bought it at and what I sold it at. So sometimes if the corporation's opening, and you know right off the bat, like, all right, there's going to be a lot of value here, you're going to sell it for a lot, you do the buy-in price higher. Say I bought in 100 shares at $10,000 each. And that way it helps you with the tax down the road. If there's nothing on the table, if it's just I need to open a corporation, I don't know what's going to happen with it financially, I have nothing else happening financially that will affect it, there's a rule of thumb that you can do 100 at $1, 100 at $0.01, and that's fine, and then divide it between the owners. You do have rights as a shareholder. So you have rights like, for example, to financial disclosure from the company, right? Anybody who has shares, there's actually a section of the Corporations Act that says, like, here's all the rights of a minority shareholder. So the company, for example, if you bought shares in a restaurant, they're like, hey, sorry, like we're a software company now. You can actually like go to court for that type of thing. So if you own shares, it's like you have certain rights that protect your ownership, but it doesn't mean you're necessarily going to get the dividends. If you're running your business day to day and you have 10 shares or 100 shares,
it doesn't really
it's
matter.
Not really going to change things. Right. Like it usually has more of an effect when there's multiple owners, right? Because shares is how you decide. Unless you have a shareholders agreement, the shares just decide the voting. I also want to talk about directors and officers. So officers are basically the named directors in a corporation. The president, the secretary, the treasurer, those are the legally required ones. You can also have a vice president, and I think the general manager can name. I can't remember. There's like one other one that you can name, but it's not really going to have a lot of effect just for the shareholders. Makes them feel good to see it listed on the government registry. So the main difference in the day-to-day operation, if you're a sole shareholder, you just have all the titles. You have the director, you have the shareholder, and you have all the officer roles. You're the president, the secretary, and the treasurer. If you have all those roles, then functionally, you're not going to notice anything in your day-to-day. You're not going to be like, oh, now I'm acting as president, now I'm like, you just run the business, right? If ever comes up that a bank form requires the secretary's signature, you sign it. If there's more people in the company, I usually recommend for people to keep the sort of control rules, right, with the sort of controlling people. So if there's 2 founders and 3 investors, I would have the 2 founders, maybe one is president secretary and one is treasurer. So keep the control with the people who are actually founding the company, right, who have actually started the company. What do these rules actually mean? They mean that you're going to get named if you get sued, basically. That's the most functional reality of being listed as an officer on a company. If somebody goes to sue that company, they look up what's called a corporate profile report. They'll see your names there as officers. They'll be like, all right, like if I'm going after somebody, these are going to be my main people to go after. It also means that you have more responsibility. For example, as the signing officer, right? Generally, if there's nothing written, the officers are the people who sign for bank accounts, for checks, for those type of things. But you can have in a shareholders agreement, you can write out for the directors to take on the signing officer roles. So the role of officers is, for most cases, in fact, for a vast majority, is really a formality. Like most companies, even if they get sued, it's the company getting sued, right? It's not, you have to be in a pretty extreme situation for the people to be sued. So most of the time, the person signing checks is like a general manager at the corporation who's been given that authority. The people dealing with the bank are the directors. And as a formality on the corporate registry, you have president, secretary, treasurer, but it doesn't really impact much of the day-to-day. Directors have director's liability, so they can be sued. Technically, anyone can be sued. Anyone can start a lawsuit against anyone. The officer, you have more exposure, right? Because if the person looks up the company, they're going to see your name. So if this person's like, I hate these guys, I'm going to take them into court, they'll probably sue anyone that they see listed, right?
Do they have a ground to sue? Or?
Well, that's the question, right? Because people get vindictive, they get aggressive, they start lawsuits, right? In corporate law, you have to break what's called the corporate veil. Corporate veil is like this fiction of my corporation is here, and as a person, I'm outside the veil. So to get to me, they have to break through, essentially. I don't know, legal fiction that they construct. But basically, the idea is you have to show that what happened was so severe that it wasn't just something the business did. It was something that the person did. So, for example, if I'm a director, so I am a director, right? I have SM Legal as my legal practice, and I'm the director and sole officer of that company. So if I call up a supplier and I order like $10 million of goods, and I have him deliver the goods, and I know 100% I can't pay for these goods, he's probably going to sue me personally, right? He's probably going to try and pierce the veil to get to me. He's going to say, you know what, this was director's negligence, because not only did the business not need these $10 million of goods, but you personally knew, right, that I'd incur this expense, you knew there was no need, you were acting negligently in entering this contract when you had no financing for it. So in that type of situation, that's pretty extreme, right? But in that type of situation, they could probably sue both. Say, you know what, you were acting negligently as a director. But if, for example, if I do work for a client and they don't like the work I do, which has never happened. I'm not saying that as bad. It's actually not happening.
I can vouch for that.
Yeah. No, but if somebody, just for example, if somebody says you drafted a contract, I'm not happy with it. My employee ended up doing some bad stuff because this contract wasn't good, and I had to pay, $10,000 to resolve the situation. I'm now going to sue you. So for something like that, they could try to break through the corporate veil, but it wouldn't happen. I can almost guarantee it wouldn't happen. Last couple of things I want to talk about here. We touched on share certificates. I want to talk about shareholders' agreements. I always recommend them when there's multiple shareholders. I understand it's a bit of a cost for the client, the company at the outset, because they're a bit longer agreements, right? We're not talking like a 2-3 page document. They're usually like 15 to 20 pages. Basically, what the shareholders agreement does is it lays out the rules for how the shareholders interact with the company. If there are no rules, the defaults are in the OBCA, the Ontario Business Corporations Act, and it doesn't really have a lot of content. That's just the reality. It has a lot of laws on certain things, but in terms of the relationship between shareholders and the corporation, it doesn't really have law. It has the protections for minority shareholders, and that's pretty much it. It doesn't have, for example, any rules about what happens if a shareholder dies. Right? What happens if you're running the company and something horrible happens and somebody passes away. The OBCA is basically silent on that. There's no rules one way or the other. So to resolve those problems, you'll get shareholders agreements, which are essentially contracts between the shareholders and the company. And those contracts will lay out what happens if somebody dies, what happens if somebody gets sick, what happens if somebody doesn't want to be a part of this company anymore, right? What happens if they want to leave? What happens if more people want to be part of the company? Right? What happens if we want to bring people in? It'll lay out what happens if there's a dispute, right? If there's a problem between the shareholders, what do we do about it? So all those rules that the OBCA doesn't touch on, that's where the shareholders agreement is going to come in. If you're running a company as one person, as I'm sure you can tell, you probably don't need this type of agreement. You just kind of set the rules for yourself and make those decisions. But even at two people, I think a shareholders agreement is, I wouldn't say always necessary, but always helpful and pretty much, as close to necessary as you can get, just to protect the operation of the business as you grow. There are two times that I think it really comes up. The first is, when you're getting investors and growing as a company, right? Because that's a time when if somebody's coming into the company, they want to see how it's run. And if you can say, hey, we have, a well-constructed shareholders agreement, we are all on the same team, we've all been working on the same page, we put this together as a group, we've been following the rules, on X, Y, Z things that happen for the company, and we adhere to these guidelines in our agreement. So for an investor, that's a very positive, okay, I know what's going on with this company. This seems like a well-run, organized company. I don't have to worry, right? We have 5 shareholders, and I don't know what any of them think or what any of them feel like their entitlements are. It's all down on paper. And then the other situation is I was in a meeting earlier and talking about this, the corporate divorce, right? When things fall apart. Without a shareholders agreement, those situations get really messy. They just become, there's no word in the law. Like, let's say you have a situation where one person wants to keep the business going, the other person's like, this business isn't making money, let's close it. The OBCA doesn't say anything about that. So if you don't have an agreement that says what will happen for that situation, it's really just each side sort of, you've got to kind of test the tolerance of the other side. That's really how it's done. Just to sort of go off the record about it. You kind of have your client's position, and then you basically push against the other party's position and see if you can get, for example, if you have the client who wants to dissolve, you see if you can, through direct negotiation, get the company dissolved. Because there really aren't a ton of other options. The other way to do it is called an oppression claim, which is a court claim. But going through that process is a very long and timely process. It involves courts making a decision about closely held companies, which is always tough because you have 3-4 people who run a business. They get maybe 10 hours in front of a judge, and then the judge makes a decision. I know 10 hours seems like a lot, but if you've been running a business 10 years, it's very, very little time to make your case. So it's really like a roll of the dice. Not always, if you're a minority shareholder who's been locked out of dividends or something like that, there's some good oppression claims that are pretty clear cut. But if it's a corporate divorce, right, a situation where no one's right or wrong, it's just 2 shareholders are in a fight or have different opinions, it's really a toss-up to go into court because you have so little time, right, to get that opinion across to the judge, and the judge is going to make a decision. Maybe you have a judge who, their personal bias is they're a more conservative approach. Maybe their personal bias is they're, really aggressive. They like the idea of more judicial interference, and that's all going to affect what the outcome is. And an oppression claim, the way it's written out in the OBCA is that courts can do there's 20 different orders. So you can go and say, okay, this company isn't working, I want it solved. And the court can say, no, we're actually going to do, we're going to force you to disclose to the court every 3 months your business operation, and this person has to sell these shares. And the court can change, you can go in for one thing and they can say, no, this is actually what's best for the company. And suddenly you're in a second mess because you're all right, now all our corporate activities have to run through, judge whoever who's deciding on things. Anyway, it's a bit of a spiel, but it's all to say that agreements, in those 2 situations are very important. If you're running a company yourself, or if you're running a company, maybe with a family member, right, somebody who you're pretty confident in that relationship, it might not be necessary, but most of the time it really is. Last thing I'll just touch on briefly is the distinction between partners and shareholders. Because when people are in a corporation, if there's 2 people in the corporation, all the time, I'll hear this from clients, they'll be like, my partner said, right, technically it's a shareholder. If you're in a corporation, if it's 2 or more people, you are shareholders. You are not partners in the corporation. So sometimes there can be a little confusion about that. But shareholder, if you're not in a corporation, so you and another person are working together, right, there's no corporation, there's no incorporated entity, you're partners. You're in a partnership. So that's the distinction there. But if you tell me or your accountant or your other lawyer, this is my partner in the corporation, they should be able to figure out what you mean, and if they don't, That might be a red flag.